It is possible for a beneficiary or person interested in the estate to challenge a will that may be invalid. There are a number of elements that a will needs to be valid in British Columbia. First of all, the will maker must have actually had testamentary capacity while signing the will. That means that the will maker must have understood what a will is. He or she must have understood what assets he or she had, and they also had to understand what sort of moral obligations they had to family members. If a will maker did not have testamentary capacity, then the will can be challenged on that basis. It's also necessary that a will maker actually had knowledge and understanding of the will he or she signed. It's not as though if they just signed whatever paper was thrust in front of them and they didn't actually read it, that will would necessarily be upheld. They need to understand who they're providing their assets to once they pass away. The final key element for a valid will are formalities. There's legislation in BC requiring that a will maker sign the will in writing in the presence of two witnesses who also sign that will. It's also important that those two witnesses not be interested parties in the will. They shouldn't be beneficiaries. Of course, a will could very well appear to be valid, but if it was actually the result of undue pressure by a family member or perhaps even a family friend, then that will can be overturned as a result of undue influence. So if you're the beneficiary of an estate and you have reason to believe that a will may be invalid, timing is very important. It's usually recommended that you file something called a notice of dispute before the executor of that will obtains probate. That will halt the process, make sure you can have your say, and challenge that will.